Hello and welcome to the third in this mini-series of webinars on preparation for the end of the Brexit transition period from a data protection law perspective. This is the third of the videos in this series, and I very much recommend that you watch the first video on an overview of data protection law from January 2021 onwards before watching this video, because there are some concepts and acronyms that I'll be referring to, assuming that you have watched the first video. So if you hear terms that you're not familiar with, as I say, I recommend you go back and watch video 1 and then come back to this one. This video is focused on EU representatives. It's for UK-based charities or other organisations that use personal data, whether that's as a controller, i.e. making the decisions about what data you collect and use, or I think less commonly for charities as a processor. That's where you're using personal data on behalf of a third party, for example, in the course of providing a specific service to that charity. So you're a UK-based charity, you're using personal data, and you don't have offices or branches or establishments in the EU. The concept of establishment I referred to in the first video, but you are offering goods or services to people in the European Economic Area, or perhaps less commonly for charities, you're monitoring the behaviour of individuals in the EEA, the European Economic Area. So assuming that you are planning to continue offering goods and services, or perhaps even monitoring people in the EEA from 1st of January 2021 onwards, you may need to appoint an EU representative in order to comply with the GDPR. There are some exceptions to this requirement. There's a blanket exception for public authorities, but that won't apply to most charities. The other exception that could apply is where you are only occasionally doing this sort of data processing. So you're only occasionally offering services to people outside the EEA, or occasionally monitoring, and you're using low risk personal data, and you don't do large-scale processing of special category, that is sensitive personal data or criminal offence data. So there's a couple of questions that you'll need to satisfy yourself about there before you can say that you don't need to appoint an EU representative. The first one being, is the processing that you're doing large scale? And there's guidance published by the European Data Protection Board, the EDPB, or approved by the EDPB at least, which refers to the guidance separately published by the Article 29 Working Party on appointing a data protection officer. And that contains guidance on, in the DPO context, what's large scale. So you have to go to that guidance and see whether what you're doing is large scale. As things stand, if your charity has already given consideration to whether you need to appoint a DPO and decided you don't need a data protection officer because you're not doing large scale processing, the same rationale will apply here on your decision as to whether to appoint an EU representative. But as well as not being large scale processing of special category or criminal offence data, you also need to be doing it just occasionally. Again, GDPR doesn't contain a definition of occasional, and the EDPB guidance refers you back to some Article 29 Working Party guidance, this time on maintaining your records of processing activities, or ROPA. And that in turn talks about what's occasional. We know it's a pretty low threshold. It means basically that the processing isn't performed regularly. That's obvious enough, but it's also outside your regular course of business or activity. So it really has to be something quite one-off or very sporadic in order to fall outside of the requirement, it seems. So when do you need an EU representative? Well, as I described in those scenarios above, you don't, as a charity, have a branch or an establishment in the EU, but you are going to continue regularly processing or using the personal data of people who are in the EEA. So you're still going to have to comply with the EU GDPR from 2021 onwards. And again, if you don't know what I'm talking about when I talk about the phrase EU GDPR, go back and watch the first webinar in this mini-series on data protection law post January 2021. And because your charity doesn't have offices or some other base, you'll need to appoint a representative so that those data subjects can enforce their rights under the EU GDPR. So what exactly does an EU representative do? Well, a representative or rep will act on your behalf in order to comply with the EU GDPR. So the main things they'll do is to liaise with individual data subjects. For example, if they make an individual request under the GDPR, the EU GDPR, such as a subject access request. And the rep will also deal with any EEA supervisory authorities, so the ICO equivalent in those countries, on your behalf. Now, it's important to be clear that this doesn't mean that your charity isn't still ultimately responsible for complying with the EU GDPR when you're using those EEA people's personal data. So, for example, even though your European representative will communicate with the EU data subject making a subject access request, it would still be your charity that would be directly responsible for actually complying with the right of access under the EU GDPR. They're effectively just your spokesperson. That's not to say that the EU rep doesn't take on some responsibility and risk. Recital 80 of the GDPR, which is a sort of introductory paragraph for interpretation only, it's not law, is very much of the view that supervisory authorities in the EEA, so ICO equivalents in an EEA country, can take enforcement action, including issuing fines against a rep, an EU representative, in exactly the same way as they can against a controller or processor that has appointed the rep. To an extent, that's reflected in the European Data Protection Board guidance, although slightly less wide-ranging view. So I suspect that if you are entering into some sort of service agreement or commercial arrangement for an EU representative to act on your behalf, they'll be looking for some indemnities from you and potentially some insurance cover for you to have in place in order to cover them for any losses they might incur as a result of being your representative. Taking a little step back, who can be an EU rep? Well, effectively any person, organisation or company established in the relevant EEA member state. So that could be a law firm, for example, or a consultancy firm, or an individual consultant. I've seen several offers from various providers doing the rounds. And if it is a company or firm that you are going to appoint as your rep, then the EDPB guidance recommends that you have a named lead or a person in charge that you can contact. It could be another group charity if you have branches of your charity or federation structure, you have other charities in the relevant EEA country. And one representative can act for several controllers and processors. The only real requirements is that the rep has to be based in the EEA country where you are going to be processing people's data, and they need to be able to represent you. One thing that's not permitted is for your EU rep to also be your external data protection officer. I think that's going to be quite unlikely anyway, but it's just to bear in mind that those two roles are fundamentally incompatible. So how do you go about finding and appointing someone as your EU rep? Well, you have to put in place a written mandate for the representative to act on your behalf. As I say, in reality, if you're using a consultancy or another company to provide EU representative services to you, they're going to be charging a fee, and they will probably have a service agreement, terms and conditions, a contract of their own that they want to put in place. Obviously, your charity will need to review the terms of that contract before entering into them. If this isn't a commercial arrangement, so if, for example, you're using another charity to be your rep, there should be some form of written arrangement between the parties. That could be an MOU or something, setting out the terms of your relationship. So once you've found and appointed your EU representative, what do you need to do then? Well, you need to give them a copy of your records of processing activity, your ROPA, and that you need to give them updates that you might make at various points to the ROPA. You need to give people in the EEA details of your representative. So probably the easiest way is to add this information to your privacy notice. You might also give people the rep's information up front when you first collect their data, perhaps depending on the nature or sensitivity of the services that you're offering to people. And then finally, supervisory authorities in the relevant EEA countries, so your ICO equivalents in France, or Germany, or Spain, need to be able to find details of your EU representative too. Now, you don't need to proactively send that information to each supervisory authority, but the ICO recommends that this info should be somewhere that's quite easy to find. So perhaps on your website as well as being in your privacy notice. And then finally, on this topic of EU representatives, just for completeness, I should say that the UK government intends that after the transition period ends on 31st of December 2020, the UK GDPR will require controllers and processors outside the UK to appoint a UK representative if they are still required to comply with the UK GDPR. Again, look at the first video in this series for more information on when the UK GDPR will continue to apply to non-UK organisations. Thank you.